Welcome everyone to HSA's How to Maintain Compliance with the Pot of Gold. Thank you all so much for joining us. Our moderator for today's call is Beth Allen. She will be answering the questions you send through the Q&A today as opposed to the chat. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. While the new client learning portal is being improved, we will be sharing the recordings in the GetWise Wednesdays emails. If there are any portions of this call that you may have missed, by Friday you will receive an email with a link to the full recording. The PowerPoint slides used during today's presentation will be shared in the same email. Additionally, for those of you who are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In the next 24 hours, I will email the program ID number for you to record and submit to the HR Certification Institute. This credit will only be available to those who listen to the actual webinar, not to those listening to the recording later. Additionally, you must have remained on the call for the entirety of the webinar to be eligible for this credit. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Patrick Myers, Vice President and Counsel, and Carol Wood, Vice President and Counsel for NFP's Benefits Compliance Department. We're very excited to have them speaking with us today, and it is my great pleasure to hand the call over to our speaker. Patrick, the floor is yours.
Thank you, Leanne, and happy St. Patrick's Day, everyone. I hope everyone is doing well today. Although it is known that nothing makes you want to grab a shillelagh and drive away snakes, quite like listening to somebody drone on and on about HSAs, you have the luck of the Irish today, because these lovely people are going to be your leprechauns for the next hour. We're going to provide you with a high-level look at HSAs and some of the more particular issues revolving around this benefit. And although we will do our best to make sure that this presentation is blarney-free, we are obliged to provide you with this disclaimer that this is intended to be used for general guidance purposes only, and it is not intended to constitute legal advice. With that out of the way, this is the time I'm going to tell you what we're going to be telling you over the next hour. First, I'm going to provide you with an overview of the HSA rules. Then Carol will take up with eligibility requirements. Then I'll come back with rules on contributions. Then Carol will talk about distributions. I'll take up tax reporting. And then Carol will wrap it up with some takeaways. And throughout our presentation, we will also be answering some frequently asked questions that we see all the time when people ask us about HSAs. So first, let's look at the HSA in an overview. The first thing to keep in mind is that HSAs is not a group health plan. They are individually owned accounts that are owned by the employees. They provide tax advantages, and they are designed in large part to help employees become aware of costs and encourages comparison shopping, getting more power into the hands of the employee as they take up issues regarding their own health care. It is also a way for employers to control expenses. Now, I say that HSA programs are generally not group health plans. And what does that mean? Typically, they're not subject to ERISA, HIPAA, COBRA, or the ACA. For instance, the ERISA requirements for a plan document, the file Form 5500s, as well as certain fiduciary obligations do not apply. However, much like ERISAs and voluntary plans, employers must limit their involvement in HSAs to prevent ERISA's application. Specifically, the employee establishment of an HSA must be completely voluntary. Employers can't limit the ability of employees to transfer their funds to another HSA. They can't impose conditions on the use of those funds. They can't make or influence HSA investment decisions. They cannot represent that HSAs are part of a group health plan, and they cannot receive any payment or compensation in connection with the HSA. Now remember, HSAs are often paired with HDHPs, and although HSAs are not group health plans, HDHPs are group health plans that must comply with those laws. Well, let's discuss a little bit about individual ownership. Again, as I mentioned before, the employee owns this account. That means the employee sets the contribution level, the employee determines investments, They are free to transfer to another custodian. They can maintain this account after the employment ends. This also means, however, that the employee is ultimately responsible for determining eligibility, making contributions within the applicable limits, using funds for qualified medical expenses, maintaining records of their expenditures, and reporting the tax on Form 8889, which comes with the Form 1040, and to correct any excess contributions. Now, what are some of the tax advantages of the HSA? Contributions to HSAs are often done pre-tax through a Section 125 cafeteria plan. This means that the employee and employer contributions are not included in the employee's income. And the employer also saves on payroll taxes on those contributions. Above-the-line deductions are available for contributions outside of payroll, however. Now, earnings growth within the HSA, such as interest, dividends, capital gains, are not subject to federal tax. So there is some potential here as a retirement savings vehicle. However, and distributions, I should also mention, to pay for qualifying medical expenses are not taxable. Although we will discuss shortly what happens if they make distributions that are not qualifying medical expenses. So at this point, I will pass this over to Carol to talk about eligibility.
Thank you, Patrick. Thank you. Happy St. Patrick's Day to everybody. And thank you, Patrick, for a great overview, setting the stage, giving us that big picture. I'm going to discuss next the eligibility requirements. This by far is the area where I think we see the most compliance issues, just a lot of confusion in this area. So we're going to discuss it in some depth. Now, the HSA Eligibility Basics are outlined here. The first requirement is that the individual must have qualified high deductible health plan coverage, and they also must have no other impermissible coverage, and that would include Medicare. And the individual cannot be claimed as a tax dependent of another. So those are the basic requirements. Let's look at them each in more depth. The 2021 qualified HDHP requirements. First, the plan has to be a major medical plan providing significant benefits. The minimum deductible for 2021 is $1,400 for single coverage and $2,800 for family coverage. And family is just the employee and one other individual or more, but it just has to be one other individual. The maximum out-of-pocket limit is $7,000 for single coverage and $14,000 for family. So the basic idea here, of course, is that no benefits, including prescription drug benefits, can be paid until the deductible is met. That's the general rule. There are some exceptions. Those would include dental and vision expenses and also preventive care. Preventive care would be health exams, certain screenings, routine child care, immunizations, and basically the ACA preventive care definition is incorporated for non-grandfathered plans. But in addition, IRS Notice 2019-45 expanded the preventive care definition to allow for certain specified expenses for chronic conditions to be covered. This is completely optional, but for example, the employer could elect to include insulin for diabetes in its definition of preventive care expenses, statins for heart disease. So it's the employer's option to include any, some, or all of those expenses from that specified list. Out-of-network expenses do not need to be applied to the maximum out-of-pocket limit. Drug coupons, this is referring to manufacturer assistance for brand name drugs, and there's been a question, how is that treated if the individual has an HSA and they're covered by an HDHP? How is that treated towards the cost sharing limit? There's been a lot of confusion. HHS did come out last year in the parameters for 2021 and stated the HDHP does not need to count financial assistance for brand name drugs towards the cost sharing limit. However, state laws may impact the treatment by insured plans. States have come out with laws that really, for an insured plan, would dictate how those coupons are handled. Okay, so that's the required coverage. Now we're going to review the impermissible coverage. And there is another screen. It's not just what's here, but really what we're referring to is any coverage providing non-accepted benefits before the HDHP deductible is met. So any first dollar coverage, this is going to include Medicare Parts A, B, C, or D. And we're referring to entitlement. That means the individual has to be eligible and enrolled, not just eligible. To be very careful here because the coverage can be retroactive. That would occur if an individual didn't enroll in Medicare when they were first eligible. They chose maybe to keep working, delay Social Security, Medicare, and then they're enrolling at a later date. And then when they do that, there's a possibility that the coverage can be retroactive for up to 6 months. So if they're not aware of it, they may end up having over-contributed for a particular year and have an excess contribution that would have to be removed. So it's always a good idea, for individuals to contact Medicare or CMS to confirm their eligibility and their the coverage start date. Medicaid is also impermissible coverage, as is TRICARE, and receipt of VA medical benefits during the prior 3 months. There are some exceptions. Preventive care services or medical or hospital care for a service-connected disability, or medical or hospital care received from the VA by a veteran with a disability rating. Those would not affect HSA eligibility. And then moving to the next slide, general purpose HRA or health FSA coverage is also impermissible. That includes spousal coverage, meaning if the employee's spouse has a health FSA, most likely that's going to cover the employee as well. Technically, a health FSA could be designed to cover only employee and not a spouse. You rarely ever see that, so that's really presents a problem with HSA contribution eligibility. Now, this restriction does not include a limited purpose HRA or FSA, such as one that just covers vision and dental expenses or post-deductible coverage. FSAs with a grace period or carryover may extend the period of time when an individual is ineligible to contribute to his or her HSA. And we're going to discuss that in a little more depth on a later slide. But of course now we have, with the extensions under the CAA and in IRS Notice 2021-15, that this issue is really exacerbated when you have an extended, for example, grace period. Finally, on-site medical clinics or EAPs can be impermissible coverage if they provide significant medical benefits. And this is really a facts and circumstances analysis. There's no bright line. It's not, that they necessarily is impermissible coverage. You really have to look at the particular EAP or clinic. So, for example, an EAP that's just providing only referral services may not present an issue, but one that is staffed by professionals, medical professionals providing counseling and care may be. Same with an on-site medical clinic. Is it just providing preventive care, maybe flu shots, just treating workplace injuries, or is it also providing sick visits and prescribing antibiotics that wouldn't be considered preventive care? So that's just something to keep in mind when you offer benefits to those types of facilities. I'm going to start with our frequently asked questions. Is HSA eligibility impacted if the employee's spouse is enrolled in Medicare or other impermissible coverage? And the answer is no, only the employee's coverage matters. If a spouse or child has other coverage, the employee is still eligible for the HSA. However, as we just talked about, if the employee is also covered under the spouse's impermissible coverage, such as a health FSA, that prevents a problem. That renders the employee HSA contribution ineligible. It doesn't, though, affect the contribution limit if the spouse, for example, is not has impermissible coverage. The coverage for, let's say, they're enrolled in Medicare, the coverage for the employee would still be the applicable family limit, assuming they're covered by the HDHP. Let's look at in more depth the effect of an FSA grace period or carryover. How do these impact HSA eligibility, and how can the adverse effect be avoided? HSA eligibility is determined on the first of the month. So with a grace period, the employee is not HSA eligible until the first of the month after the grace period ends. So Brian's 2020 calendar year FSA has a 2.5-month grace period. He would not be eligible to contribute to an HSA until 4/1, the first of the following month. But if he spends down the FSA to 0 at the end of 2020, he would be HSA eligible on January 1st of 2021. So that's one way to avoid the grace periods if you spend it down to 0 at the end of the prior year. A carryover from 1 year will generally block HSA eligibility for the entire following year. However, a plan could be designed to convert the carryover balance to a limited purpose FSA for employees electing the HSA with the HDHP. And it can also be designed to allow employees to waive or forfeit the carryover balance. And this guidance isn't new. This goes back to IRS guidance in 2014. But these are design options if there is a carryover to preserve HSA eligibility for those who don't wish to participate in the health FSA for the following year. And then finally, under IRS Notice 2021-15, for at least 2021, a plan could be amended to permit an employee to make a prospective election change to convert a health FSA to a limited purpose FSA mid-year. That's optional. The employee would have to elect it, amend the plan, and open up such an election. But particularly with employers looking to, extend grace periods, given the CAA relief, that may be a temporary option to review. Let's say an employer is looking to add an HDHP and HSA mid-year. They already have a health FSA. What are the considerations? Well, the employees participating in the health FSA would not be eligible for the HSA until the end of the FSA plan year or grace period if applicable. The addition of the HSA and HDHP is not a qualifying event permitting individual employees to change their FSA election. The employer could choose to make changes to the entire FSA to allow employees to access the HSA, and we discussed some of those earlier, limited purpose FSA, and there's temporary relief available under IRS Notice 2021-15. So sometimes when the permitted election change rules are more restrictive with the health FSA than other types of coverage. So it's just something to keep in mind when introducing it mid-year. You do have some relief in 2021, but otherwise that's a concern. Telehealth services. Do telehealth services adversely impact HSA contribution eligibility? Generally, yes, telehealth services could negatively impact HSA eligibility if providing non-accepted medical benefits before the HDHP deductible is met. However, under the CARES Act, participants can maintain HSA eligibility even if first dollar coverage of telehealth services is provided. So this relief applies to plan years beginning on or before December 31st of 2021. And it extends to all type of care. It wasn't just COVID diagnosis and COVID testing and diagnosis, but all types of care, but just for that limited period as of now. What are the employer's obligations to verify an employee's HSA eligibility? And they're quite limited. The employer is only responsible for determining that the employee is covered by the HDHP and has no other disqualifying coverage sponsored by the employer. The employee's age, that would be for catch-up contribution purposes. The employee really bears all responsibility, as Patrick mentioned earlier, but the employer should work with the HSA vendor to educate employees regarding these eligibility requirements. It's not required, but it will be a benefit to everyone and help to avoid any excess contributions. And with that, I will turn the stage back over to Patrick to discuss, now that we're eligible, the HSA contribution rules.
Thank you, Carol. Unfortunately, we can't fill our HSAs by catching a leprechaun and forcing him to transfer his pot of gold. We have to do it like the man said, the old-fashioned way. We have to earn it and then contribute a portion of it to the HSA. Although if we're lucky, our employer can contribute part to that as well. And so these are going to be the rules that we have to follow when we make those contributions. Now, there's a warning. We have some math coming up, so grab your Guinness. Here we go. Now, the first thing we want to talk about are the maximum limits, that is, how much we can actually put into HSA on any given year. And as you can see on our slide, we have a little chart that determines the maximum amount by year and as well as by tier of coverage. So that in 2021, if a single coverage is $3,600 and family coverage is $7,200. Note that those who are 55 or older are eligible for a $1,000 catch-up contribution, which is in addition to those limits. And eligible spouses can both make catch-up contributions, but they can't make them to the same HSA. Family coverage is any coverage other than self-only. I think Carol discussed this briefly earlier. Other individual coverage does not need to be HSA eligible for family contribution limits to apply. Limits include all contributions to the HSA, so that includes both the employer and the employee contributions. And contributions are due by April 15th of the following year. So, for example, 2021 contributions have to be made by April 15th, 2022. We have a general monthly rule when it comes to determining contribution limits. And that rule is your contribution limit is determined by the number of months in which you are HSA eligible. An employee may need to prorate the applicable IRS maximum based upon his months of HSA eligibility during the year. So for example, Harry enrolls in HDHP single coverage on January 1st of 2021. He becomes entitled to Medicare with his Medicare coverage commencing on October 1st, 2021. So he is eligible for 9/12 of the 2021 calendar year. That's because he was eligible from January to October. So his maximum 2021 HSA contribution is going to be 3/4 of $3,600, which remember is the limit for the year, which is going to end up being $2,700. His catch-up, because he's 55 or older, could also be prorated to 3/4 of $1,000, which again was the contribution limit for a catch-up, or $750. So Harry could contribute $2,700 plus $750 in catch-up for a total of $3,450 for 2021. And he has until April 15th of 2022 to make those contributions. If Harry failed to prorate the maximum and contributed $4,600, he would need to remove the excess $1,150 prior to the tax filing deadline for 2021, and that includes extensions. Otherwise, he will owe a 6% excise tax on all those excess amounts. There's an alternative rule. It's called the last month rule, and this rule states that you can make the full contribution up to the annual limit even if you are not eligible for the entire year, provided that you are HSA eligible on December 1st of the year and you remain HSA eligible for the entire following year. This is termed the 13-month testing period, for example. Patricia enrolls her family in HDHP coverage on November 1st, 2021, and remains HSA eligible through December 31st, 2022. Following this rule, she can contribute the full $7,200 family contribution for 2021. Now, if Patricia failed to remain HSA eligible throughout 2022, her 2021 contribution would be prorated to 2/12 or 1/6 of $7,200, which is the maximum 2021 family contribution amount, remember, or $1,200. If she contributed the full $7,200, she would be subject to income taxes and an additional 10% penalty tax on the $6,000, which would be the difference between her actual contribution and the permitted prorated monthly amount. So the rule can help individuals maximize contributions, but it's important to fully understand the testing period requirements. You don't want to run afoul of that and have to pay that additional 10% penalty tax. So now let's talk about employer contributions for a minute. Again, like I mentioned earlier, employer contributions count toward the applicable maximum limit. And once employers make those contributions, they usually cannot claw them back. There are some exceptions to that, but that's the general rule. Also, I think I may have mentioned this earlier, employer contributions are completely optional. And the type of contribution the employer wishes to make, for instance, like a matching contribution or an incentive-based contribution, as well as the timing of those contributions, for instance, they can make those contributions as a lump sum or on a monthly basis, are totally at the employer's discretion. Front loading early in the year can help employees cover the deductible or out-of-pocket expenses for medical expenses. But if the employee terminates employment or the HDHP coverage mid-year, the employer won't be able to recoup those funds if they did it front-loaded. And the employee may also find themselves with an excess contribution. So it may be preferable to fund those contributions on a monthly or a payroll period basis. And I should also stress that if the employer chooses to make the contributions, they should clearly communicate eligibility requirements as well as timing for employer HSA contributions and all the HSA materials they provide to their employees. And now I'll take a minute to discuss non-discrimination rules. Most employers permit pre-tax HSA contributions to be made through Section 125 cafeteria plans. And employees must be permitted to change those contribution amounts at least monthly. And since pre-tax contributions that are subject to Section 125, cafeteria plans are also subject to Section 125 non-discrimination rules, which prohibit discrimination in favor of highly compensated employees, or HCEs. For 2021, an HCE is any officer, a more than 5% shareholder or owner, or any individual with compensation in excess of $130,000 in 2020. The Section 125 tests review eligibility, that is, who can participate in the plan, contributions and benefits, which is to say which benefits are available to the participants, as well as utilization, which is just another way of saying who's actually benefiting from that plan. Employers can vary contributions between bona fide classifications of employees, for instance, classifications by location or occupation or hire date, provided that the result does not favor HCEs. Testing early in the year is always advisable, so any potential testing issues can be addressed. Test failures result in HCEs losing the Section 125 tax advantages, and doing this non-discrimination testing and waiting to the end of the year to do it, it may be too late to make those changes. Employers that make post-tax contributions are subject to more restrictive comparability rules. Those rules generally require comparable employer contributions to be made to employees in the same category, full-time, part-time, and former employees, as well as coverage tier. So our first question in this section is, how are contributions impacted if employees' tier of coverage changes mid-year? Well, under the full contribution rule, they can contribute the greater of the full amount based on the tier of coverage on December 1st, or the total of monthly contributions based on coverage tier. So John has single coverage effective January 1st, 2021. He gets married and adds his spouse to his HDHP on August 15th, 2021. So to determine the monthly total, he had single coverage, for 8 months, or $2,400, and family coverage for 4 months, or $2,400, for a total contribution of $4,800. Or you can get the full contribution of $7,200 for 2021. The next question we get into this section is, what should be done if an individual contributes to their HSA in excess of their maximum limit? Now, the individual will need to take corrective action to remove the excess. Excess contributions must be included in gross income and may be subject to a 6% excise tax if not timely removed. But generally, to avoid the tax, the removal must be done by April 15th after the end of the tax year of the error. Now, it's always advisable to consult with a tax professional if you're looking at excess contributions and trying to figure out a way to deal with that. The next question we have is, can an employer recoup a mistaken employer HSA contribution? Generally speaking, as I mentioned before, when an employer makes that on contribution, the employer generally can't claw that back. There are some exceptions. Now, if the individual was never HSA eligible, or if there is clear and convincing evidence that there was administrative or process error in making that contribution, or they're mistakenly contributing more than the statutory maximum permitted by the IRS, then those are circumstances under which the employer's contribution could be clawed back. But any recoupment must be made by the end of the tax year. So for 2021, it would have to be done by December 31st, 2021. And so now that we've gone through that, I'll hand it back to Carol to talk more about HSA distributions.
Thank you, Patrick. So the individual is eligible, they've made the proper amount of contributions, and now they want to go ahead and use those the funds for eligible medical expenses. So let's talk about HSA distributions and the basics. Just move to the next slide. The basic distribution rules. HSAs are designed to pay qualified medical expenses of the HSA owner and the owner's spouse and tax dependents. Generally, IRS Publication 502 describes such qualified medical expenses. And it includes, of course, the pre-deductible medical and drug expenses, co-payments, dental and vision costs. I mean, the HSA is really designed to be with the HDHP to pay those pre-deductible medical and drug expenses. Per the CARES Act, over-the-counter medications now also are considered qualified medical expenses even without a prescription, as are menstrual care products if incurred on or after January 1 of 2020. A tax dependent generally refers to children under age 19 or under age 24 and a full-time student. So it's important to know the HSA rules do not incorporate the ACA age 26 rule. So that distinction is something to keep in mind. Additionally, HSA distributions for qualified medical expenses are tax and penalty free. Now, there are some timing issues to be aware of. There's an establishment rule, and what this says is that a qualified medical expense must be incurred after the HSA is established. Establishment is actually based upon state trust law, and that typically requires that a trust be funded. So the HSA may not be established until funds are deposited. As an example, Shannon enrolls in an HDHP for 2021 and elects to make semi-monthly HSA payroll contributions. She completes the paperwork with the HSA custodian in December of 2020. Her first payroll contribution occurs on January 15, 2021. Shannon's HSA is established on January 15, 2021. Expenses occurred prior to the date are not eligible for tax-free distribution. However, there is an exception if an individual has a prior HSA. If the prior HSA had a positive balance at any time during the 18-month period preceding the new HSA establishment, then the new HSA is actually deemed established when the prior one was. So let's say Shannon had an HSA with a prior employer that was established back on St. Patrick's Day in 2018, and the last funds from this account were distributed in July 2020. Then Shannon's new HSA that she just opened with the new employer for 2021 is deemed established on March 17, 2018, and any qualified medical expenses incurred from this date are eligible for tax-free reimbursement. So this is a good rule to know about. It was a bit obscure, I think, when it was first announced, because many people didn't have an HSA. But at this point, many of us, including myself, have had more than one HSA. Now, on the other side, conversely, the shoebox rule says that HSA distributions for a medical expense can be made at any future time. So if an individual incurs an expense in 2021, unlike, let's say, an FSA, they don't have to have it reimbursed in that same plan year. They can have it reimbursed in the HSA several years down the line. For someone wishing to perhaps, maybe they're investing their HSA and they want to enjoy the tax-free earnings and savings, then they can, as long as they keep good records, they can have that expense reimbursed from the HSA several years later. The taxation of HSA distribution, from a tax perspective, there are three basic types of HSA distribution. The first that we've been speaking of are the tax-free and penalty-free type, the qualified medical expenses. Now, generally, these do not include premium costs. However, there are important exceptions. These would include COBRA, long-term care insurance, premiums while receiving unemployment. So, for example, somebody who's on unemployment who purchases coverage even through the exchange, that would be reimbursable through the HSA. Medicare and employer-sponsored retiree coverage for those over 65. However, there's an important exception for Medicare that would exclude any Medicare supplemental policies. Transfers to other HSAs are also tax-free and penalty-free. That would be when you're wishing to maybe transfer to another custodian, you refer their investments, their services. That can be done as a direct rollover. The second category are taxable distributions, but where no penalty is incurred. These would include distributions made after age 65 for non-qualified medical expenses. So someone over age 65, maybe they want to take a distribution for home improvements, for vacation. They can do so. They would be taxed on the amount as income, but they wouldn't be subject to an additional penalty. Death and disability distributions are also taxable, but not subject to a penalty. And then finally, the third category that we're generally trying to avoid are those distributions that are taxable and penalized, which is any other distribution, for example, for an HSA owner under age 65 for a non-qualified expense, and that's taxable and subject to a 20% penalty. So that younger person may want to think twice before they use it for a vacation. Okay, let's go to frequently asked questions. Taxation of non-qualified expenses. What happens if the employee uses HSA funds to pay for a non-qualified expense? As we just said, the distribution is included in the account holder's gross income and is subject to an additional 20% penalty tax. It's not applicable, though, if it's considered a mistaken distribution and it's returned to the HSA no later than April 15th following the year in which the mistake was known. So this would involve, let's use an example. An individual uses the HSA to pay for medical expense, and then the carrier reimburses because it was determined to be classified as preventive care, So they've mistakenly made a withdrawal from the HSA and they want to return those funds. They would really have to reach out to the custodian then and probably complete a form attesting to the fact that there has to be clear and convincing evidence there was a mistake, that it was such a mistake, and that they're returning the funds to the account. They could, let's say, send a check to return the funds to the account. So that's how that process would work. And then there's really no additional reporting as long as the custodian, you're filling out the paperwork of the custodian and they're identifying it correctly, it wouldn't appear as a distribution on the distribution form, the 1099 SA. The 20% penalty tax also does not apply to, as we discussed, non-qualified distributions following an account holder's death, after the account holder is age 65, or after the account holder becomes disabled. And with that, I will turn it back to Patrick to briefly discuss the tax reporting.
Thank you, Carol. Governments are always after our lucky charms, so let's spend a few minutes talking about tax reporting issues. The employer reporting obligations, HSA contributions are made through cafeteria plan, are reported on box 12 of Form W-2 with the code W. The custodian reporting obligations are that they have to report all contributions to the account for the year on Form 5498-SA, which is filed with the IRS and sent to the account holder by May 31st the following year. Custodian also reports all distributions from the account in the year on Form 1099-SA, which is provided to the account holder by January 31st of the following year. Account holders who had HSA contributions or distributions must report the activity on Form 8889, which is included with the individual tax return, often the Form 1040. Form 5329 may also be required to report any excess contributions and earnings. So first question we get in this area is, does the FCRA tax credit include contributions made to HSAs? The short answer is no. The amount of qualified health plan expenses does not include employer contributions to HSAs. However, eligible employers who sponsor an HDHP can include the allocable amount of the qualified health plan expenses that they paid or incurred. And in this slide, we're including a link to the IRS FAQ page that talks about what can be included for the tax credit. So at this point, I'm going to give it back to Carol to take us to the end of the rainbow and give us some compliance takeaways.
Thank you, Patrick. As Patrick explained in the beginning of the presentation, HSAs have great tax advantages and can help employees to pay for medical expenses. So they're really a wonderful vehicle. But as we've outlined here, there are a number of compliance issues to be aware of. Employees benefit greatly from education on the HSA eligibility and distribution rules. Employers should plan proactively when implementing an HSA for the first time. It's important to work with the vendor so the process and communications are coordinated. And I really can't emphasize this enough. I think this is not even just when you offer for the first time, but to have a good relationship with the HSA vendor, to know what communications they're going to be sending to your employees. I would say perhaps as much as 20% of the questions that we receive really result from administrative issues. For example, an employee doesn't open up an account and then the employer wasn't aware of it and they were planning to make a contribution. And those types of issues are largely avoidable. Many banks are custodians and they have to comply with their own federal laws, so they likely have a process. They're required to know their customers. So if the account can be set up with a bank, the employee may have to verify some information in order to get the account set up. So it's important to work with the vendor, know the process, know what communication the employees are receiving, because, as I said, those situations are really preventable. It's also important to verify employees are not covered by impermissible coverage through the employer. We do see this inadvertently, with, for example, the on-site clinics we discussed, the EAPs, other types of coverage that the employer is offering, thinking, oh, it's a benefit, or helping the employee, and not thinking that it falls into the category of impermissible coverage because it's providing coverage other than preventive care before that statutory deductible is met. With respect to the employer contribution funding, it may be a good idea to consider funding it throughout the year rather than in a lump sum. As Patrick explained, you can certainly make a lump sum up front. I know employers like to do that to help employees pay their medical expenses. But then there's the issue of, well, what happens if an employee terminates? Are they getting a windfall, and do they also have an excess contribution as a result? And I think it's also important with employer contributions, you're not obligated to make any, but it's important to spell out the terms of that in your HSA materials, like who's eligible, what the timing is, so there aren't questions after. We often receive them, well, this employee only worked part of the year, or they're terminating, and are they still eligible to get the contribution? And really, it's you set the terms for that and spelled it out. But if the employee relied on what you communicated or didn't communicate clearly, they may have an argument there. So you just want to spell out the terms in your materials. Important to perform the Section 125 non-discrimination testing early in the year if possible. Particularly important if you're varying contributions by different classes. That's where you're going to see the most issues, as Patrick mentioned. So that's important. And then finally, the final takeaway is that there are many details that we could not cover here. We tried to give you a good overview, but we do have a white paper, and a shout out to Linda in New York for really spearheading that project. It was collaborative, but she really pulled the weight on it. It's a terrific paper, and we expect it to be released before the end of the month. So if you're interested in receiving a copy, we would say please reach out to your NFP contact, and we'll put you on the list to receive it. And with that, I think I'm going to ask Beth. We thank you for joining us, and I'm going to ask Beth if any questions came in that may be worth discussing at this point.
Sure. Thank you so much, Patrick and Carol. I have thoroughly enjoyed this presentation about HSAs and all of the, points about leprechauns and pots of gold. So thank you for that. We have gotten a few questions, and I'll kind of throw out some of them. Going back to the eligibility portion of this presentation, we talked about the fact that there is obviously impermissible coverage that would make you ineligible to receive, an HSA contribution. But we got a lot of questions about whether or not someone could potentially choose to pair their high deductible health plan with an FSA. Can y'all speak to that?
Carol?
Sure. Yeah. I mean, there isn't a restriction on that. The restriction really, you can have the HDHP and other coverage. That's not the problem. It's having the HSA and the health FSA that presents the issue, unless, of course, it's a limited purpose FSA, because your general health FSA is going to provide the coverage for other than preventive care before that deductible is met.
Right, and the only thing I'll add to that is that also, if you have post-deductible FSAs, that's also okay to have with HSA. That is to say, FSAs that kick in after you've met your deductible.
Right. Yeah. I think the confusion with some employers is that they think, okay, because you cannot have, let's say, an FSA if you have an HSA or a high deductible health plan, they don't realize you could choose to have a high deductible health plan and an FSA. You just couldn't have that FSA and the HSA. Right?
Right.
There's going to be some people who want that design because, for example, they might be an employee who wants your high deductible health plan because of the low cost of the premium, but they might be enrolled on their spouse's HRA, for example, right? And so
Yeah.
that employee might want your high deductible health plan, but also want an FSA so that they have their own saving mechanism for medical expenses. So thanks for addressing that. We also got a lot of questions, I think, about the whole excess contribution issue, right? And so we got some questions about, if you do have people who end up with excess contributions, what does that correction process look like? And would it potentially result in them having to adjust, the employee's W-2?
Yeah, that's actually, from my perspective, that's a pretty complicated question, and it's probably best asked of the tax advisor about how best to do that. Normally, we see that on the individual account holder side, where they reach out to the custodian and ask for and to deal with how to disperse those excess contributions.
Yeah, I think that's spot on as far as, the W-2 and what has to happen, because that's technically a tax form,
Yeah.
right? But if you do have excess contributions, then you do potentially end up with you having to basically give that person back those contributions and tax them on it. And so the rules, as far as like, is that refund taxed in this current year, or is it taxed to the year to which the HSA contribution originally applied? That's where you're going to want to kind of get in there with your accountant or tax advisor and figure out kind of the mechanics in that way.
Right.
And so, yeah, that was, I think, another set of questions. I'm going through here and trying to see if there's anything else that I think kind of came up multiple times. I would say we did get some questions about kind of like figuring out what can be reimbursed from an HSA and this kind of definition of qualified medical services. Do y'all have any kind of pointers on how a plan would know, or an employee would know what those qualified medical expenses are or include?
Well, again, that's, and of course it is the individual obligation and entirely really, and we outlined that. Publication 502 would provide an outline of the expenses, and that's probably the best source. It can be, of course, the expenses for the employee, spouse, and dependents, but not up to age 26, as we referenced with the health FSA. But I think publication 502 is probably the best guidance. You are going to have some expenses that, may be difficult to determine if they're, medical care or not. You have, things like, sunglasses. Well, they're not, but their prescription they are. In some cases, you have some kind of ergonomic chair, and there's certain rules like, well, what's the difference? The difference between if it's prescribed by a doctor, the cost of that chair and just the cost of another chair may be reimbursable. So you do get into some tricky situations or ones that you can't clearly classify. I think a lot of expenses don't fall into that category, though. And then, as we said, there are certain premiums, but I think that publication would be the best source.
Thank you. And so I'll kind of bring up the last question, and I'll tell my own kind of story. We did get a question about employers or employees, let's say, who had a child who is not a tax dependent. And this is always kind of an interesting thing, and I will share with everyone on the call that I am a bonus mom, so I have a stepson. And interestingly, I have an HSA, and, I could use the HSA for my spouse and for my biological child. But my bonus son lives with his mother over 51% of the year. So he is not our tax dependent. And so I cannot use my HSA to pay for his coverage, even though he is covered under my plan at NFP. Now, mind you, we got some questions from employers who were kind of like, essentially, what is the employer's responsibility to make sure that the employee is only using their HSA on amounts that are qualified medical expenses? And the reality is like, we started off saying that an HSA is an individual account that, it belongs to the employee. But as part of that, it is the employee's responsibility to make sure that what they spend it on is actually qualified medical expenses. And so although I think your role as an employer is to somewhat educate them, some of you put that in your benefits guide, kind of what can be reimbursed under an HSA and what cannot. And some of you might point them to publication 502, which Carol mentioned. Some of you might give them an example list. At the end of the day, it is my job as the HSA account holder to make sure that I only spend it on medical expenses, because I'm going to have to answer to the IRS if I don't. Okay. And so the employer doesn't have a whole lot of responsibility, if you will, to go back and make sure that, employees are actually using their HSA in the correct way in that regard. And so I don't think that you have much obligation, but besides potentially telling them, hey, you need to make sure you don't spend it on, let's say, a child who is not your tax dependent. Okay. And so I think that, let's see, well, we have like 4 more minutes. Is there anything that any of you want to bring up as well? Diane, did you see anything in there that we want to bring up? All right. Well, I think, Leanne, we have a couple minutes or whatever, so I'll let you do kind of our ending comments, but thanks so much to Patrick and to Carol for presenting the information on HSAs today. There's a lot going on. I'm going to be honest that I'm going to commend everyone on this call because you asked us only questions about the HSA, even though I know that there are other things that are probably at the top of your mind right now. And so just keep in mind that, we're going to be putting out additional information and resources surrounding kind of the ARPA and what we're all kind of knee deep in right now. And so look to your advisors for information about things that we have coming on that topic, as well as just the stuff that we're going to get over the next several months. And so thanks for joining, and I will push this back out to Leanne to give our final thoughts.
Sure thing. Thanks, Beth. Sorry, Diane, did you want to add anything?
No, I think we're good now. Thanks,
okay.
though.
No worries. Thank you so much. Well, perfect. I'll wrap this up and give everybody a couple minutes back of their Wednesday afternoon. Again, we just want to extend a big thank you to Patrick, Carol, and Beth, and Diane for sharing your valuable time and your expertise with us today. To reiterate, today's presentation was recorded. While the new client learning portal is being improved, we will be sharing the recordings in the GetWise Wednesdays emails. If there are any portions of this call that you may have missed, by Friday you'll receive an email with a link to the full recording. The PowerPoint slides used during today's presentation will be shared in that same email. And lastly, for those of you who may have joined our call just a little bit later and who are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In the next 24 hours, I will email you the program ID number for you to record and submit to the HR Certification Institute. This credit will only be available to those who listen to the actual webinar, not to those listening to the recording later. Additionally, you must have remained on the call for the entirety of the webinar to be eligible for this credit. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners, and it helps us to make our education program as current and relevant as possible. That concludes our webinar. Thank you all so much for joining us, and have a great day.
Bye, everyone.